Hi, we're back with another episode of Mix and Matchbox. Today, I am joined by marketing and IP attorney for agencies and founder of Toerek Law, Sharon Toerek. How are you doing, Sharon?
Hey, Brent. I'm well. Thanks for having me today.
Absolutely. Thanks so much for being on the podcast.
Yeah.
Actually, this is so relevant to what we do as agency owners. So, definitely very interested in chatting with you about some of these questions here. So, first thing right off the bat, you've built a practice that sits right at the intersection of law and the creative industry. And so that's a very specific lane. If you can walk us back to kind of the beginning, how did you end up becoming the attorney for marketing agencies specifically?
Well, so I am an IP lawyer by training, and it's what I had my first exposure to in terms of, practice areas as I was starting my career. And I have always loved and been passionate about protecting innovation and ideas. It just resonated with me or from early on in my career. And so as I started developing, my business over time, it was unique to have a small, closely held practice that focused on IP law. So I got in front of a lot of opportunities with marketers generally, and then more narrowly with marketing services companies, agencies. And there was really just nobody helping them specifically who understood their industry and their blend of sort of art and entrepreneurship, if you will.
Yeah.
And that was really attractive to me. So yeah, I've been focused on building a business that serves independent agencies for, over 15 years. I founded the firm that I own now almost 13 years ago to target agencies and their specific needs.
Well, that is wonderful. And I know that you and I had a second to chat right before we started the podcast. And, I think I had mentioned, and I'm sure that you hear often that there's frequently law firms that will come encounter with agencies and, maybe they'll do some work, but, having an agency feel like you really get them is kind of tough because, agencies need legal help, they need legal services, but at the same time, there's not a lot of law firms that practice in this exact specific area, in this niche. So I think it's extraordinarily helpful. I know that most agency owners, they might hear the term legal or law and might think expense or headache or worst case scenarios. You argue it can actually be a profit engine. And how would you say that looks like in practice?
Yeah. One of our core beliefs at my firm is that legal affairs should be a profit center for your agency. The tendency is to think of legal as either obstructive, something putting a big obstacle in your way to getting where you want to go, or something that requires a lot of investment of time or capital. And sometimes, frankly, it does, but legal affairs should be a way for your agency to capture more value and more profit in its contracts with clients, in its relationships with vendors, certainly in the development of and monetization, if you will. That's a long word for saying, the ability to make money selling more of what you create. And, with an IP strategy, you can maybe do that alongside of your regular client fee for service work. So legal affairs should be a pathway to you being able to not only preserve more profit by reducing risk, but also increase your top line.
Yeah, that's great. All right. I'm sorry. I'm going to ask you for a random stat, and this might be hard to generate.
I'll try. I'm not going to make one up. If I don't have one, I'll tell you that.
All right. That sounds good. But I mean, of the percentage of agencies that you deal with, how many people have their legal stuff all together?
Altogether, I would say I'd put it at less than 50%.
Cool.
And I would say that some of them are very strong in certain areas and have not spent a lot of time or attention in others. Some of them just routinely make it a part of their operations, and they may not be 100% in every quadrant, if you will, but overall, as an agency, they are thinking proactively on a routine, regular basis about their legal operations and how it interacts with the other areas of the business.
That's cool. That's super helpful. Well, and I guess we'll dig right into one. So I guess, when you first start working with an agency, what's the IP mistake that you see most often that makes you think, oh, they don't know how exposed they are right now?
Well, I would say that one of the most frequent practices that we see that's not really friendly towards leveraging your IP for the most profit is giving too much of it away in the new business process. I think that if you're an agency that routinely does biz dev by pitching a lot or by responding to a lot of RFPs where you include a lot of strategy, a lot of ideation, without protecting your position and the IP that you're sharing in those environments, you're giving away a lot of potential profit. And for some of you, that is an intentional decision. Those are your table stakes for pursuing an opportunity. What I see though is that agencies don't always do this with intentionality. They're just doing it by default. So I think that's one major practice that I see a lot of agencies engage in. And it's not always strategic and it isn't always intentional. And so I'd like to see more sort of stopping and thinking before you give away some of your best ideation without a guarantee that you're going to be able to leverage it for profit. The second thing, I know you only asked for one, but I really want to say the second thing is you're not taking the time along the way of development of your original methodologies, your original processes, procedures to easily explain them and maybe sell them one day. You should always be thinking of ways to create assets and either make them additive to the value of your agency or make them sellable. And so sometimes they're valuable because you keep them secret. That's fine. You should still be documenting them. Other times you should be more intentional about things like copyright and trademark registrations, license agreements, those sorts of things. So just the documentation and categorization of your IP as you're creating it. And so those are the top two areas of opportunity, I would say, for agencies listening to this.
That's awesome. That is like really helpful. And I mean, I'm certain that any agency owner listening, with the first one, I'm sure if you've been in a pitch meeting, a response to an RFP, you're doing the presentation and you hear the other side say, oh, that's a great idea. You instantly know whether you get that work or not, they're going to probably find a way to implement that. And so, it could be money walking out the door.
Right. Well, and we all have those stories, or we've heard our colleagues in the industry share the stories of pitching something and not winning and seeing the idea or the concept get executed either internally by the brand or by some competing agency. I mean, those are tales as old as time, right? That's not something new, but it's the lack of intentionality that I have the issue with. If you've decided that you're going to present your ideas and that is a risk you're assuming as part of your expense of new business, I'm fine with that. We're all grown-ups here, and that's a business decision that you're making. But be thinking through whether that's intentional, what your guardrails are, what your expectation is of that potential client you're talking to about what happens to that content or those ideas or strategies if you all don't move ahead with a business relationship.
That's awesome. Yeah, definitely. Great call out. For, agency contracts, this is another area that certainly, you and I talked about this right before we jumped on here. So agency contracts can be often rushed, templated, or even forgotten. And I will say, at a minimum, it's probably the first two, rushed or templated. What are the 2 or 3 contract clauses that actually protect an agency's margin and that most agencies are either missing or getting wrong?
I think there are a few of them. I think the most obvious low-hanging fruit is, are your payment terms nailed down very specifically? And most agencies are great at this. We have 30-day terms. So great. What does your language say about the enforcement of those 30-day terms? If you've signed the client's version of the agreement, even though it might seem to be a 30-day term, when does that 30 days start? Does it start when you send the invoice? Does it start when they've approved your invoice? Does it start when they say they've accepted your invoice? All this nuance. So nail your terms down, nail your work scope down very carefully. This is where lots of agencies, as I'm sure you know, Brent, lose points off the table of their profitability is they were squishy about scope, or they were not specific in their operations about when something extra outside of the scope was okay to do or not do. So those things go together, I think. So I'm going to count them as one thing. It's your payment terms with very clear language and your very clear scope, which usually shows up like in a statement of work or something, not in the master service agreement itself. And then I would say the third is your intellectual property transfer language. It's not defaulting just to the simple work for hire language that has been, known, used, and abused for years in the industry. It's thinking through with intentionality what will belong to the client at the end of the day, and more specifically, when do they own it? And it should never be until the agency's been paid in full, right? That's not going to be the language that you will see in a client presented agreement. So you have to be watchful for it and push back on it. But also, what IP are we retaining as an agency? This is stuff that we're licensing to you or letting you use without additional charge, but it's ours and we may use it again in our next client relationship. And so I would say those are the top 3 profit preserving mechanisms. And there are other things that, we could certainly talk about. Exclusivity, which every agency that agrees to it should be charging a premium for. So that's leveraging your contract for the maximum profit that you should be gaining, and things like fair competition covenants, which are, sort of the rules of the road for non-solicitation of your talent and such. I think those are the keys in most agency client agreements.
That's cool. Those are super helpful notes. And it's interesting as I think about even our own relationships and our scopes. I know that probably the challenge for agencies is, what is the factor that we can lock something down? I mentioned we do web design and development. How do we actually say this is what we're creating? At the end of the day, quote unquote, this is the product and you're limited to X. And one of the things recently we had done for ourselves was just say, hey, it's limited to this amount of pages, within a website. Now, granted, the type and size page, that was one thing that we felt like, all right, great, we can, kind of get around this. But, one thing I also noticed too was that people are hesitant to address out of scope things. They're trying to keep the client happy. They're trying to keep the project moving. And sometimes that awareness it's not something that gets better with time. I'll definitely say that as there becomes a scope problem and it grows and it grows and it grows and grows. And really, honestly, the honesty is the best policy of being transparent about it, of calling these things to attention is my only additional piece of advice. That sometimes as you get to those, as the language needs to be locked down as well as it can, sometimes it's actually, you have all those things in your scope and they're just not being addressed properly. Right. And that's where I feel like it's super helpful that you are also calling to attention of knowing that language so you can go and, and rely on it and leverage it too. So that's why it is. It's such a complicated beast and interesting to figure out, to say the least.
Yeah, I mean, this has been a challenge that agencies have had for years. And, quite frankly, the way that AI is crashing into our business models, and certainly this is not just the agency industry, the legal industry, it will face the same obstacles. But We need to be thinking differently about the way we cast our value, the way we explain our value, and the way we price for our value. And this is not necessarily a legal issue, but it shows up in the legal documentation of your relationships at some point. So, the days, I think, for agencies of time-based billing or effort-based billing are coming to an end, because AI is making the doing faster, less expensive. So what we need to be having the conversation around is, what value are we creating for the client, pricing to that, and then using this technology behind the scenes to make it as efficient as profitable. And then making sure that our contracts are reflective of that value and that relationship.
You couldn't have said it better. That's great.
I mean, we have to deal with it, right? AI is coming for our business models. It's not, I don't think it's going to, put us all out on the street job wise. I think our jobs are going to, adjust and evolve, but it's going to make the conversation about what our clients are actually buying from us different. And we need to be ready for that.
Absolutely. Well, actually, AI is a perfect segue into the next question, and it's actually very relevant, because agencies are using AI tools themselves, and they're using it across strategy and copy and creative, often without thinking of those legal implications they could have. So, what are the risks that are kind of hiding inside of those daily workflows or the processes that they've maybe built up, with AI tools, that an agency, leader doesn't realize that, maybe they've already taken on some risk?
Yeah. So I think of this as a rubric of 2 + 5, and I'll tell you what I mean by that. There are two top areas in my experience so far, and we've been working hard for the last 2.5 years to really be thinking through risk management regarding AI for agencies. So the top two legal areas of risk for agencies listening to this are inadvertent or unintentional IP infringement. That means using work generated out of the tools and taking it to market on behalf of our brand clients that might infringe on some third party's intellectual property. And there's no way to know in advance, because these platforms are certainly not going to share their trading data sets with us. So we don't know where it came from, and there's really no way to predict whether the output, I mean, there are some obvious indicators. If something spits out a Coke logo, you're not going to use that for a soda brand, right? But the examples are not that straightforward. And so infringing on somebody else's intellectual property is the number one area of risk. The second area of risk that I don't think we're talking enough about is breaching confidentiality or breaching data privacy laws as a result of the ease of using some of these platforms. The challenge with this is that the way most modern agencies work, with a multiplicity of devices and a multiplicity of work arrangements that are virtual or analog or a combination of the two, is whose accounts are our talent using when it comes to using AI. Are they on a free unpaid version that they're using as a contractor to the agency and dumping in all this client provided information to do their work that is exposing it? Are they creating direct response campaigns by feeding in personal information of customers into some AI platform without guidance? So those are the top two areas of risk: IP infringement, data privacy, or confidentiality breaches. And there are things, and we've started really talking more tactically with agencies about what are some practical steps that an agency of any size or scale can take to sort of get ahead of this and create a culture of compliance and governance that at least helps your team stop and ask the questions. They're not in the business of being lawyers for their clients, but they should know when an issue looks like it's something we need to stop and check into.
Yeah, that's that. I think that's so helpful, is kind of the curiosity around it, of not necessarily just taking everything as it's like, just fine, or these are the tool sets that we use, or this is, just thinking a little bit before, and maybe even the inquiry could help maybe prevent a really big problem.
Yeah. And I so that, we've talked about the two, the really 5 steps I think any agency can take, and you can build one on the other, or you can tackle the lowest hanging fruit for you, whatever makes sense. The first is policy making. Take some time simply to write your policies around use of AI platforms as an agency. It doesn't have to be fancy and flowery or legalese or any particular length, but something is better than nothing, right? You can always enhance it, evolve it later, and you should, because the tools will change and the practices will change. But you need an internal policy that your team members can follow around using AI in your operations. Which platforms, which use cases, what questions should we be asking the client? What should we be telling the client before we turn the work over? There are other things, but those are good starter things to address. And then an external policy, right? It's 1A and 1B, internal and external. What are our policies that we want the client to understand, and what should we be telling them about our AI practices so that they know we're forward thinking about this as an agency. We're not just being reactive. Agencies can look like heroes and leaders and teachers with their clients by demonstrating that they've pre-considered this stuff, that they're not just reacting, but they're being proactive. So that's policy making. Secondly, every agency listening needs relevant terms in its contract and its client services agreements, in its independent contractor agreements, probably in its vendor agreements around AI use and liability and exposure. And then I would say, rounding out the top 3 of those is know the terms and conditions of the platforms that you're using. And look, I'm a lawyer, and even I feel like this is watching paint dry to try to, read this stuff, but pick the platforms you use most frequently and understand what they say about things like who's responsible if somebody's intellectual property gets infringed, or who's responsible if somebody's data is breached. And, spoiler alert, it's not going to be the platforms. It's going to be you as an agency, or it's going to be your client, or both of you. So be familiar and be fluent in the language there.
Oh, cool. That's great. And actually, I've got one more on the topic of, AI here, and it's around the ambiguity around who owns the AI generated content. And so, the IP is definitely one thing, but let's say that it was something generated by AI, and, agencies are using these tools more and more to, whether that be pump out content for websites, maybe it's actually images that appear in blog posts, but at some point down the road, maybe OpenAI might be like, oh, that was generated. We have a mark on that image. We know that it was generated with our platform, and we, need some, credit back for whatever that got posted out there. I'm just hypothetical. But, what is the current conversation of, that's going around that, legally? And then how should agencies maybe be protecting themselves for their relationships with their clients right now?
Right. So, where we stand right now with the copyright law around this is that anything machine generated, no one can own copyright in it. So the agency can't own copyright in it. The client can't own copyright in it. And the agency, the platform, the AI platforms are happy to let you own whatever rights that can be ownable, because they know nobody can own it. So it's not any skin off of their noses to say, we're not going to make, so they're not going to make any IP claims in general. The challenge is, are the agency's communications with the clients creating the understanding that nobody can own any exclusive AI output? That's the first part of the problem. The second part of the question that I usually get, in addition to the one you just asked, is, well, what if we've used AI, but we've also added some human input into the final work product? Or it's a blend of AI, inspiration and human, editing or creation. Who owns it then? And part C to that question is there any specific amount of human contribution that we can add to that thing that can make it ownable? No, there's no specific amount. There's a very easy answer to that question. There's no number. There's no rule or law that says if it's 50% human and 50% AI, then you can own it. What the copyright law does say, though, is to the extent you can separate out the AI generated work from the human created work, for example, AI generated illustrations, human created copy, right? You can own the human created elements. You just cannot own the AI generated output. So this means you have to have conversations with your clients. That's the first protection strategy, because you asked about how agencies keep themselves safe. The second part of it is you need language in your client services agreement that indemnifies you, the agency, against mistakes like, IP infringement or an ad claim that appears in the ad that you didn't generate. And then you need human guardrails along with it, both on the agency side, of course, but you need the client to assume responsibility in the agreement for reviewing and approving work product before it hits, the public.
Yeah, definitely. Wow. Again, more good notes. All right, I've got a weird hypothetical to throw your way.
Oh boy. Okay.
Sorry. Yeah, don't mean for all the randomness here, but actually it just came across my mind about let's say somebody's likeness is similar to that of an AI generated photo. And I'm thinking of the Daily Show and Jon Stewart, like he thought his face was in this image, that he saw, and it was clearly AI generated, but at the same time, he was like, that looks strikingly like me.
Mm-hmm.
Is there a chance that, somebody would have a claim that looks too much like somebody, and therefore, that image would, need to be taken down, even though it was machine generated and theoretically based off nobody?
Yeah, I mean, there is a possibility. I mean, one of the intellectual property rights that we don't talk a lot about in marketing and advertising is the right to publicity. And that's the right to use of your likeness, whether that is the visual depiction of your likeness or your voice or something that resembles you. And so just because there's not a copyright law issue with an AI generated image, if someone's likeness is used in any sort of commercial capacity without their permission, they still have the right to have a say in that and a compensation for that. And there are some specific state laws in the US right now, New York, California, regarding use of synthetic, basically entertainers or individuals in advertising. And so you should never default as an agency to thinking you're safe just because something got spit out of AI. If it looks like Jon Stewart and you're selling, an air conditioning system and next to a picture of Jon Stewart, you're going to be held responsible for that. But you don't need to be Jon Stewart. You could be you or me. And if we don't want our image associated with something and it's being used in a way that it could be, degrading or defamatory or any of the things, you still have publicity rights. And so marketers need to be aware of that.
Yeah, definitely. Well, on the legal lines of things, I think the FTC has recently gotten more aggressive about disclosure requirements. And so what are the most common mistakes that, agencies might be making with running influencer or UGC or user generated content campaigns? And what does a, painful FTC surprise look like?
Well, a painful FTC surprise will ultimately look like, a big fat fine, but there are steps they can take before that are also uncomfortable. And that's censure, right? That's continued monitoring. That is certainly bad publicity because they're going to make and publish their decisions around your conduct. And also, if we're talking dollars and cents, lost relationships between agencies and clients because agencies didn't flag this properly, right? I think that the practices that are most likely to get agencies in trouble when working with creators or influencers include things like they are making claims about their use of the product or the product's features and benefits that are not provable, that are not sustainable, or that mislead, right? And that is an advertising principle that's as old as time, but it's shocking to me that it's still a line that gets skirted. And the more you use influencer talent and creator talent, the more likely this is to happen, because not every people have different levels of compliance and understanding of the law, right? So that's first. Secondly is the failure to disclose by the creator or the influencer that they have a commercial relationship with the brand. And that doesn't even need to be the exchange of money. It can be the exchange of samples of product, the exchange of special privileges, like being invited to some event that isn't open to the public, et cetera, et cetera. So it's, inaccurate claims. It's failure to disclose financial relationships or commercial relationships. And then thirdly, I would say it's lax monitoring of the content creation practices of the creator. You need an agreement with the creator or the influencer that not only addresses FTC rule compliance, but IP practices. You need to know if they're using AI to create their content. You need to know that they're promising you they're not going to knowingly infringe on some third party's copyrights or publicity rights. So it's just a laxity in practice that is sometimes just the speed of doing business, sometimes a lack of training, and sometimes just the excitement or the virality of working with a particular creator or an influencer. Creators and influencers are much more sophisticated now than they were 10 years ago. You're way more likely to find them to have some sort of professional management around them. And the practices have been around for so long at this point now that they understand sort of, ethereally that there's some rules they should be following. They might need your help understanding them with more clarity, but I think there's less excuse these days for influencer campaigns or creator-led or UGC generated content to violate the rules, because we've seen so many examples of how to do it right and how not to do it at this point.
Yeah, definitely. That is true. By the way, I'm fully AI generated. I'm
Prove you're you. Tell us your social security number right now.
There you go. Well, I'm sure you work with a lot of agencies, not only through, maybe, their legal, contracting and all IP issues, but, maybe going through acquisitions. And this is, commonly happening. I definitely know a few agency owners that have, sold their agency, and there's a ton of, pressure and stress around financials and books. But, I'm sure that maybe the things that get let go are the ideas behind the scenes that may have a lot of value. But, what have you seen kind of get eroded or not, kind of estimated into an agency value that, kind of goes away maybe before they sell?
Right. Well, I'm not definitely the marketplace has heated up over the last 24 months. We've done our share of deals, both selling and buying. And we're seeing deals amongst much smaller agencies than we would have a few years ago even. And there's lots of reasons for that. But I think the missed opportunities here for agencies who want to get themselves in a position to be able to consider a transaction in the future is, and ironically, Brent, these are the same things that you should be doing to keep your agency strong and profitable today. But two things. First of all, monitoring and auditing, and I know that's an ugly word, but keeping track of, let's put it that way, your client contracts, both from the perspective of not only profitability, but how long are they going to be in effect for? Do you even have written agreements with your top clients, or are they still current? There's a number of really successful and profitable small and mid-sized agencies out there that have legacy client relationships for years, and they've made literally millions of dollars from those relationships, and there's no contract. Either there never was or there used to be and it expired. So if you want to be viable or sellable, I should say, you need written agreements for somebody to be able to assume. Otherwise, those client relationships are not going to be worth to a buyer what they're worth to you today. So that's the first thing. Audit your agreements for term, for existence, and also for assignability. What kind of hoops are you going to have to go through legally to get the client to agree that its relationship could transfer from you to a buying agency, right? So that's contract, auditing your contracts. The second is, this gets back to this IP documentation. You can move the needle significantly on the valuation of your agency by having a body of intellectual property to sell in addition to your book of client business. But that requires documentation. It requires protection having been taken along the way. And it requires the right registrations and contract strategies along the way. So those are two things, two areas of homework to be thinking about if you think you're a few years away from considering a transaction. I mean, if you're looking to do it quickly, then your options are more limited. But if you have a few-year horizon, then now's the time to get serious about this stuff so that you put yourself in the best position.
Cool. That's a great heads up, because yeah, I'm sure that's probably not crossing everybody's mind as they consider the acquisition or sale. It's more like, who are clients? How much are those client retainers worth? And things like that. But
it's another example of legal affairs as a profit center for your agency, really, is thinking about how they impact the top line, and what's more relevant to top line than how much money you can get selling your business to somebody else.
Yeah, that's great. Well, you've already provided so much good data. I have two more questions here. And the next is really just around, and I even think of, ourselves when I, going to relay this question, but like a lot of indie agencies are kind of like bootstrapped and they're trying to minimize overhead. And we seriously, when my business partner and I started this like 20 years ago, it was a very easy business to get into because we didn't need a whole lot. Eventually we got an office and we got employees and we got a whole bunch of things, but in terms of being a, investment, there's not much more that you need than a computer, a place to actually do the work. Yeah. And boy, now you could probably even do a lot of it from your phone, which is insane. But like, it doesn't take much to start an agency necessarily. But, how does an agency owner know that they've crossed the line from, being scrappy and fine and kind of putting things together and doing what they needed to like, now they're a real legal liability? Is there a threshold that you could kind of gauge on that?
I think the best way for me to answer the question would be to say to owners listening to this, that if the only occasion on which you bring legal into an issue is when it's on fire, then you're missing opportunities to manage your investment and your cost, because laying down some proactive strategies and tactics in your operations to manage legal affairs over time is less expensive than reacting just on a scattershot approach. So I would say if you feel like you are infrequently involving legal, or only when things like, it seems like something's really like a dumpster fire, that's a signal that you're not using legal effectively enough, in my mind. I think if you are negotiating your client relationships from a position of reactiveness, in other words, we'll sign the client's agreement because they're not going to want to negotiate off of one of ours anyway, that's a good signal that you're not being proactive about your legal affairs, because you have way more leverage at that stage of a relationship, no matter what size your agency is, than at any other point. And so you're leaving opportunity on the table, in my experience. So I think those are two good signals that an agency isn't taking best advantage of using legal affairs to be stronger and more profitable. And I get it. Look, when you're bootstrapping, when you're in the early years, but at some point, it's just like any other investment you make to leverage over time in your business. And it's one of the only ones I can think of that not only preserve your bottom line from a risk management perspective, but can be used strategically to help your top line, which is all we're worried about in those early years, right? It's get the revenue in, get the revenue in, and use everything at your disposal to help you do that.
Absolutely. Well, now I'm going to ask you to kind of boil it all down. If an agency owner is listening and they want to take one concrete step this week, or let's say soon, because this week's maybe, right now it's Thursday, but when people listen to this, maybe another day of the week. Regardless,
yeah,
pretty short. But if they wanted to do something soon to reduce their legal risk, what's the highest leverage thing that they could do?
Lowest hanging fruit is pull out your client contract, pull out the tool you're using to document your client relationships. If you tell me you don't have one, then that is your first piece of homework. You need one. I don't care whether you sign your client's paper a lot or not. You need your own contract, and it needs to be updated every 6 to 12 months. So that is, if you do only one thing, and you came back to me in a couple months and said you did it, that would be excellent progress for most agencies.
That's awesome. Everybody listening, have a contract. There you go.
Have one and update it. If you have one that you haven't updated it in the last 6 months or so, dust it off and update it.
That's awesome. Well, cool. Well, Sharon, this is fantastic. You've provided an incredible amount of information. And, I know that you have a podcast as well. Let me know, where people should find you, and then also a call out for your own podcast too.
We do. Well, first of all, Brent, you asked awesome questions. So thank you so much for the conversation. Our podcast is The Innovative Agency. It is not a legal podcast. It is a podcast truly about sort of looking around the corner and innovation in the agency world. And so we'd love to have you join us for a listen anytime. It's for agency owners and leaders. And you can learn more about the firm at legalandcreative.com. And I'm very active on LinkedIn. So it's Sharon Toerek, Toerek.
Awesome. Well, Sharon, thank you so much. This has been amazing. And I've really appreciated the conversation. So thanks for being on.
It's my pleasure. Thank you, Brent.
Great. Well, this has been another episode of Mix and Matchbox. I'm your host, Brent Feldman. We'll be back soon with more content. Please like and subscribe. Thanks.